Everyone. It's great to be back at the law school, taking a little bit of break from my sabbatical. Um, so my task here today is really to set the context for our discussion that will come after. So to give you a little bit of summary of all the court maneuvering that has happened, right, for the past more than decades or so. But focusing particularly on the ongoing legal challenge that was launched by Nell back in 2021. But just to set the context, I thought I will briefly kind of give you a background about how the whole case emerged, just in case that you're not aware of or you're not familiar with the case. So Nell, as you know, was originally from Grenada. She came to Canada in December 1999, and she, was able to find work like many migrants coming to Canada. So she decided to stay in Canada even after her visa has expired. Somewhere between 2006 and 2008, Nell's health condition unfortunately deteriorated to such a point that it was said that her health and really her life was in danger. And so sometimes in summer 2009, Nell decided to apply for a coverage under the Interim Federal Health Program. For those of you who don't know, that is a federally run, public funded healthcare coverage, typically for refugees and refugee claimants, but it also covers a larger group of people than those two groups. And in 2000 and at that time, 2009, despite the application, the federal government said no, right? You don't qualify, again, because the program, in their view, is specifically reserved for those specific groups, namely refugees and refugee claimants. So Nell challenged that decision, and unfortunately, both the federal court and federal court of appeal found against Nell, and the leave to appeal to the Supreme Court of Canada was denied. And so having exhausted all domestic legal challenge, Nell then, with the help of people like Bruce and her lawyers, decided to lodge a complaint against Canada before the UN Human Rights Committee. And as you know, the UN Human Rights Committee is tasked with, among other things, trying to adjudicate these individual complaints with respect to potential violations under the International Covenant on Civil and Political Rights, right, the ICCPR. So that really brings us to what precipitated the current litigation that, as I mentioned, was brought by Nell a few years ago. The real, the kind of the trigger for the current court case has to do with the fact that back in 2018, the UN Human Rights Committee actually found in favor of Nell, right, finding Canada having violated her right to life and non-discrimination as guaranteed under ICCPR, right, Article 6 and Article 26, respectively. And so let me just briefly talk to you about how the UN Human Rights Committee came to that conclusion. With respect to the right to life, the committee held that, well, this right entails a corresponding duty on states, right, to adopt positive measures to protect people from unnatural or premature death, as well as to ensure people's enjoyment of a life with dignity. And as you can see, it's a much more robust understanding of right to life than we typically associate with that concept here in Canada, at least under the charter, in a charter context. Now, in relation to healthcare specifically, according to the Human Rights Committee, what this means is that governments have a responsibility at least to provide access to existing healthcare services that are reasonably available and accessible when lack of access to the healthcare would expose a person to a reasonably foreseeable risk that can result in the loss of life. And according to the committee, Canada breached the right to life in that sense, right? By not providing publicly funded healthcare to Nell, again, at a point in time where her health was said to be at a life-threatening situation. At the same time, the Human Rights Committee observed that Canada's differential treatment, right, between people with legal status in Canada and those without, for the purpose of determining IFHP eligibility, was contrary to the right of everyone to equal protection of the law. What's interesting about that finding is that it confirms that immigration status is a prohibited ground of discrimination under international law's equality guarantee. And any distinction, right, made by government on that basis is presumptively discriminatory if it is not objective or reasonable. And according to the Human Rights Committee, because the consequence of that differentiation in this particular case resulted in a risk to Nell's life, right? That means the differential treatment cannot be considered either objective or reasonable. And so in light of those breaches, Canada is then ordered by the Human Rights Committee to provide Nell with effective remedy, which would include, for example, adequate compensation for Nell, and this is the part where I think it's perhaps a more profound implication for irregular migrants in Canada more generally. Right? It says that Canada must take all steps necessary to prevent similar violations in the future, including reviewing national legislation to ensure that irregular migrants have access to essential health care to prevent a reasonably foreseeable risk that can result in loss of life. Now, in Canada, as some of you would know, UN Human Rights Committee's decisions are not considered legally binding in of itself. However, under international law, state parties such as Canada are under an obligation to give these decisions a great weight, and they must cooperate with the committee by acting in good faith in following up on these decisions. So what did Canada do in response to the Human Rights Committee's decisions in this case? Well, in February 2019, it responded by stating that it was unable to agree with the views of the Human Rights Committee, both in relation to the facts and the laws that was used by the Human Rights Committee in reaching its decision, and therefore it would not take any measures to implement the views. And I think that there's much to be said about the version of facts or the interpretation of international law that Canada prefers, which in my view, is problematic. And I'm happy to get into those issues in the Q&A if there's interest. But I think more fundamentally, right, the fact that Canada refuses to accept the Human Rights Committee's views or its decisions due to mere disagreement, right, with the facts or the laws as interpreted by the views, by the committee, I think that raises concern in of itself, right? It's akin to a party involved in a court case refusing to accept the court's ruling at the end of the day because they disagree with a judge's fact finding or a judge's interpretation or understanding of the law. Right? I think in domestic legal context, we'll think of that as unfathomable. But apparently, that's what Canada decided to do in this particular case. And also, I think that this approach belittles the Human Rights Committee by ignoring the function of that committee as an expert body tasked specifically with the authority to interpret the international human rights law, specifically the rights protected under the ICCPR. Right? This is a function that is clearly spelled out in relevant treaties that Canada has signed and ratified. Canada's approach also runs roughshod of the whole point of the complaint mechanism, right, under the international human rights law. Right? If all state parties can simply ignore decisions by these issued by these treaty monitoring bodies, right, by saying that they disagree, well then, you know, what's the point of the complaint mechanism, right? It essentially defeats the whole purpose. And so for those reasons, in my view, Canada's response so far in relation to the UN Human Rights Committee's Toussaint decision cannot be characterized as acting in good faith, right? And so on that basis, Nell and her legal team decided to challenge Canada's decision, right, to not comply with the decision of the Human Rights Committee. And you know, they argue that to the extent that by not doing anything, right, by choosing not to comply with the committee's decision and effectively rendering irregular migrants to continue not have access to publicly funded health care, this violates Section 7 and Section 15 of the Canadian Charter of Rights and Freedoms, right, namely the protection of rights to life, liberty, and security of the person, as well as the right to equality. Now, before the court had a chance to hear Nell's argument, Canada actually decided to bring a motion to strike the case, effectively doing a legal version of throwing the whole kitchen sink. Canada contended that Nell's court challenge ought to be barred on several procedural grounds, and also that it disclosed no reasonable cause of action. And during the oral hearing for this motion to strike, Canada even doubled down on this dismissive approach and sought to misrepresent Nell's claim as about merely establishing a right to receive free health care anywhere in the world, regardless of one's legal status, as well as the right to an optimal level of health insurance. In 2022, Justice Perel of the Ontario Superior Court rejected Canada's motion to strike. Notably, in his ruling, Justice Perel condemned Canada's mischaracterization of Nell's claim as, I quote, a dog whistle argument that reeks of the prejudicial stereotype that immigrants come to Canada to milk the welfare system. Right, as somebody who researches in this space of migrant healthcare, where this troublesome conflation of migrants and health tourists is rampant, I find Justice Perel's call out here particularly satisfying. Now, you know, Justice Perel's decision, just so you know, it largely survived Canada's appeal, right? So the only thing that the Ontario Court of Appeal did was to reverse Justice Perel's ruling with respect to the statutory limitation period. So essentially saying that it is open to Canada when the time comes to raise a defense that Nell's court challenge is potentially out of time, right, as stipulated under the Limitations Act. So Nell's lawsuit now continues before the Ontario Ontario Superior Court of Justice. And upon Nell's unfortunate passing last year, the case now continues under the name of her mother, right, Nell Toussaint, as a representative of Nell's estate. And so hopefully the court will get to hear and decide the actual merit of Nell's argument soon without any delay. And so, you know, we'll try to keep a very close eye on this case, and we'll try to work as hard as we can to make sure that Nell get her rights vindicated.
Welcome. We'll turn it over to you.
Okay, thank you.
It's just nothing much really, just, a little of Nell's character and to let you know how strong and determined of a person she was. Nell and I grew up in different village in Grenada. So we didn't see much of each other, but we keep in touch when we can. And then she moved to Trinidad, so we sort of lost communication. But we reunited again when she moved to Canada. And we keep in contact as much as we can. And then she got sick, but she was still, in good spirit. Even though she was sick, we still used to talk. And so she when she had to get her leg, when she got sick and then she had to get her leg removed, we was very supportive of her. And then she said to me, the doctor told her, give her a choice. He said to her, you could either get your leg removed or you could keep it and die. And she said to me, she decided to move it. She decided to remove it because she didn't want to die. And that is the kind of person she is, full of life and determination. After Nell suffered a stroke and she moved to Bridgepoint Healthcare Center, rehabilitation, and I always used to visit her as often as I can. She had a very hard time communicating, but when she tried to talk, I would tell her to take her time. And eventually she will get the words out, not clearly, but I always understand what she was saying. Nell loved life. She always says she would not give up because she wants to get better. One evening I visited her and she had a computer. I asked her what she was doing. She said she is studying law. I was amazed by her courage. The words I will associate Nell with are brave, courageous, happy, kind, loving, and caring. I'm sure there are many more words to describe her, but these are the ones that I will always remember. Nell cared a lot about people, about others. Whenever I visited her, she always asked about my kids, Andrew, and my grandson. She did not leave anyone out. She never forget to ask about Johnny, which is my pet turtle. Nell was always in a happy mood. She seldom complained. I will always remember that smile, especially when I braided her hair and the nurse said to her, wow, Nell, you look so pretty. She smiled and said, thanks. One of her dreams was to be able to go back to Grenada and Trinidad so she can visit her family. She loved her family, always talking about them, especially her Uncle Desmond in Grenada. I remember dialing her mom's number for her when I visit her one Friday. And the mom asked her how she was doing. She told the mom she was all right. She told the mom that she is not giving up. She said she continued to make her voice heard. And she told her mom that her case went to the United Nations. The mom told her she is so proud of her. She loved that and said thanks. One of her favorite words, always say thanks. So much I can say, but not enough time. I truly believe if the health system did not fail now, she would have given the medical help she needed. She was going to be okay, and she was going to make a good citizen and help people that she was able to, because that's the kind of person she was. Always determined, always willing to help. And this is what I have to say right now. Thank you for listening.
Thank you very, very much, Wendine. Thank you very much.
You're welcome.
So first I want to thank Wendine and Professor Chen for framing the day for us. And I was thinking a lot about Nell today, yesterday, and in the days that we're approaching today, and why we at the South Asian Legal Clinic wanted to get involved. So I wanted to share some thoughts. So first, I really wanted to tell you who we are. And so I come to you from something called the South Asian Legal Clinic of Ontario, and it's a legal clinic funded by Legal Aid Ontario to work with low-income South Asian communities across this province of Ontario. But in addition, to think about the bigger picture around systemic issues that low-income and racialized communities face across this country. And so the work that we do is kind of two-part. One is that we do provide direct legal services. So for about 20 years now, I've been working in immigration, primarily with racialized clients and many, many, many who do not have immigration status. And as a result, myself and a number of other colleagues in Ontario in particular started something called the Color of Poverty, Color of Change. And what we do through that organization is we think in a bigger way around the systemic issues that we need to address and how they kind of interweave with systemic racism in terms of our systems and how that impacts people across the country and how that impacts in particular people with low income. I think this case was particularly important to all of us at Color of Poverty and to us at Salco because we really see the on-the-ground effects of not having immigration status on the people we work with. And not having immigration status across the jurisdictions in Canada means not having access to healthcare, in many places not having access to income supports, in many places not having access to public housing. So in so many ways, the people in this country who have precarious or no immigration status are essentially second class. I don't even want to say citizens, but are treated as second class. And in many ways, our clients describe themselves as feeling like slave labor. That is a word that clients have used for me when they have been here as temporary foreign workers. And we wanted to get involved in this case and be here with you today because it is heartbreaking to think about such a fundamental human right like healthcare and the fact that our country continues to fight and push against access to that care. And we've seen it in the Toussaint case. We see it in a number of other cases. We've seen it with Indigenous children on reserve and how we fight tooth and nail as a country to ensure that they don't have access. And when Dean gave you a really small sliver of insight into who this is impacting, the very real impact, and what I'm left thinking all the time is that with that care, many of the clients I've worked with, and I think Nell would still be here with us today, and they're not. And so I also think back to the words of Professor Chen at the beginning around this idea that when decisions are made about violations of human rights in this country, that our governments can simply say, we don't care, we're not accepting that decision. And that trend and that path is a very scary one. And so for us, why did we want to get involved? For all of those reasons. Every day I work with clients who are not covered for healthcare. And these are clients who were temporary foreign workers, and their status and their ability to get healthcare is very much tied to their right to work. So if an employer decides to let them go, that's it. They're no longer eligible for healthcare. And in many cases, they may not be eligible depending on the type of status. If you have no immigration status, then you absolutely wouldn't be able to get that healthcare coverage. And what is interesting is that our immigration system is created in such a way that it pushes people out of immigration status. And so people who come here with legitimate status often find themselves becoming what some people call irregular migrants, some people call out of status, but for a variety of reasons, the system is so complicated that it pushes our clients out of status. And then they live in a world where they're essentially not eligible for so many of the things, including healthcare. And so there are those patterns in the immigration system that create that irregular migrant status. And what is heartbreaking about it is that when you look at those cases on the ground, we know in our minds that eventually we'll be able to get permanent resident status for these people. We know that there are compelling humanitarian reasons. We know that they are here and contributing and just as much members of these communities as I am. And we do. And that is what happened in Nell's case, but it takes years. And in the meantime, the damage done to persons' physical and mental health from not having health care cannot be taken back. And so we see the heartbreak again of not being able to have that coverage and then eventually getting permanent residence where it doesn't really matter. The damage has already been done to health. And so you really think about what is a system that eventually will recognize that all of these things that you are asking for, you are entitled to, but makes you wait years and years and years to get it. It's a really, really, really horrific situation. The reality is that many of my own clients who don't have coverage are also the same people who are working either out of status, also the same people holding us up in, I'm working with clients right now who are doing childcare coverage. I'm working with clients right now who are cleaning homes. I'm working with clients right now who are very much a part of our systems, very much a part of our communities, and who don't have that type of coverage. And I think the other piece that is really critical to think about is let's drill down on who this is impacting. Who are the people who are being pushed into non-status and irregular status? And what we're seeing more and more, and the data is tricky because the way immigration collects data doesn't lend itself to this. But what we are seeing more and more is that many of these people across the country are racialized. And so there's a real intersection on this issue with an underlying issue around systemic racism and how it bears out in the immigration system and how it bears out in particular in this choice not to make coverage available to these workers who are primarily racialized. And that's been a very difficult thing for us to get Canada to acknowledge, that there's an element actually of systemic racism in this type of decision making and impacts in particular racialized communities. And what I do know from my own work is that the healthcare outcomes for these clients are horrific. My own clients will often simply resist going for any kind of treatment because they know that either they're going to be turned away if it's not emergent, or that they know that they will be asked to pay or have to be responsible to collection agencies and bills. And so they make choices to not get treatment, and I don't want to be sort of over sensationalizing, but last year in particular, I had a client I worked with who was pregnant, who really needed some ongoing, not emergent coverage during her pregnancy. Nobody would cover that for her. We were not able to get interim federal health coverage for her, much because of the reasons described in our first presentation today around the position of the government for who is eligible. And in the end, she lost her child, her pregnancy. And so there are very, very real consequences here for the people that we're talking about. Their health outcomes are far worse. And it's deeply frustrating for organizations like mine and the Color Poverty, and likely all of the people who are here today with us, to think about the idea that when we've been given a decision from the International Human Rights Court that we are in violation of our international human rights obligations, that our country has simply decided, well, we're just not accepting that decision. It's a very frustrating piece. And so I think a couple of things that we are calling on, and one thing that's been eye-opening for us is we've always been told that all of this is very tricky. And what is really interesting in Ontario is that when COVID hit, it turned out to be not that tricky. We got a directive that during COVID, everybody in the province was eligible for healthcare. And so it's doable. We know that. And we know during COVID that there was a sense that the health outcomes for everyone across this country needed to be addressed, and that in addressing them, the larger public safety issue, the larger public issue around healthcare coverage would be addressed. And so for that brief period in Ontario, that directive has ended, but for that brief period of time, everyone was able to get healthcare coverage. And so it's completely possible. And so we have ways that we can, if we have the will, make this happen for this population. And I want to reiterate that when I think about the clients I work with, I can't think of a group of people that's more vulnerable than these populations, people without immigration status, with precarious immigration status in terms of their life outcomes here. And I am a big believer in pushing, and I believe many people are, our governments to ensure that not only are we meeting our human rights obligations, but that we are expanding them to acknowledge who's here. We are creating populations in Canada with precarious or no immigration status. We have to acknowledge that our immigration systems are doing that. We have to acknowledge that many of those people are racialized people, and we have to acknowledge that then we need to address their basic and fundamental human rights. We need to address things like income and housing and healthcare, critical for them to be able to survive here. And so it's a deeply frustrating thing to work in immigration and see sort of the cross purposes of what we say. I've had, I guess, the privilege of being able to attend at the United Nations on multiple occasions when Canada has been reviewed. So most recently, the Universal Periodic Review, and prior to that, reviews on the rights of children, reviews on the Committee for the Elimination of Racial Discrimination. And in all of those appearances, Canada has come across to the world as someone who values human rights, someone who is a leader on human rights. And the reality is, when we go to speak and we talk about some of the situations happening in Canada, including this one, we are asked the question, really? That's happening in Canada? There is surprise and there is shock. And so I think we need to do more to continue to push our government. It's frustrating that this decision could not have just been implemented. It's frustrating that we have to continue this fight, but we will. I think critically, we also need to think about who we're talking about here at the base, and that's racialized communities primarily for us. And we need to think about that angle of systemic racism. And I'll leave it at that. Hopefully we'll get more into it in the conversation.
Hi, everyone. Thanks so much for being here, for making it out and attending this event. I'm so pleased and truly privileged to be part of this conversation and to share the stage with such incredible folks, heroes, really. My name is Addy. I'm a graduate of the University of Ottawa Faculty of Law, and currently work for the Canadian Union of Public Employees, Canada's largest union. So just very quickly, folks often wonder what's CUPE doing over here. And so I just want to briefly say CUPE believes very strongly in what we call social unionism. We believe that unions are not just about making life better for our members, but it's about fighting for a better world, making sure that our communities are better for everybody. In fact, when we talk about the fight for public health care, many of you will know that the labor movement and workers' movements were at the forefront of that struggle half a century ago, and that we have what we have today, whether it's public health care, whether it's weekends, whether it's social insurance. Those are all because working people join together with communities to fight for a better world for all of us. And so that's what motivates CUPE. And there's no better example of that motivation than Nell Toussaint. I want to note that for us, it's so important that we take the time to work with our members who work in a variety of sectors, whether it's education, healthcare, transportation,
airlines. We have folks across the country, 715,000 of them, who are doing and delivering important public services. And so the fact that there was such an egregious denial of access to what is a public service and what is a human right it cuts really deep for our public sector union. We also, I think it's important to note that we believe very strongly that it's important to not take victories for granted, take public health care for granted. Denial of health care to migrants, to newcomers, to folks who are undocumented, to folks who are irregular migrants, and so on. In many ways, it is really a nefarious strategy for privatization. We have to be clear that what this is really a way to help folks who want to profit from our public services to profit more from our public services. We talked earlier about, Shalini talked earlier about migrant workers who could lose their health care if they lose their job. We know that in many provinces, migrant workers are expected to get private health care from their employer. We know that for folks who, in fact, if you go on the government's website and you look at the waiting periods and what to do if you are being denied healthcare for the, whether it's a 3-month waiting period or something else, the recommendation is go buy private health insurance. So right at the outset, I just want to note that this is not just this is not a story that is just about access to healthcare for migrants. This is a story about access to healthcare for everybody. We are all Nell Toussaint in this story, because this really comes down to the fact that this is a concerted attempt to use immigration as a tool to divide us, to create these two classes of society where your immigration status can allow governments to deny you your access to healthcare, and it's only a matter of time before they come after others as well. This is why CUPE cares, because we care about building communities that are welcoming, building communities that folks can rely on their public services in. Nell's story is an inspiration to us also because Nell did work that CUPE members do. Nell worked as a childcare provider. Nell worked in cleaning homes. Nell worked as a factory worker. Nell did the work that our members do day to day, every day. We have members who fall in and out of immigration status in our union. We have members who once were a visitor, now are a refugee claimant. We have members who once were a refugee claimant and now have built links in their communities after going through an incredibly arduous Immigration and Refugee Board hearing process that refused to recognize them as a refugee, even though they may have merited it. We have members who fall out of status and who are routinely denied care in public services that they help deliver. So this is a deeply personal issue for our members as well. And so the folks that have spoken before me are really the true experts here. So I'm gonna end very quickly here and just say that we want to really truly bear witness to Nell's tireless struggle for healthcare for all, regardless of immigration status. And one small way in which we could do that was to honor Nell with our Black History Month honoree, to honor Nell as our Black History Month honoree for 2024. So as some of you will see on the screen here, hopefully folks online can also see this. This is an annual campaign we run to educate our members, to educate the public, to celebrate Black activists, leaders, community members who have really dedicated their lives to making this world a better place. And now joins folks like Member of Provincial Parliament Jill Andrew last year, who was the first Black queer woman elected to the Ontario legislature. So we're really pleased to be able to do that. We hope that everybody will join us in bearing witness to Nell's struggle, to Nell's life, and celebrate everything that Nell was able to do while she lived, and everything that she will go on to do as all of you continue on with carrying her legacy forward. I want to note also, just as I end here, I couldn't have put it better than Professor Y.Y. Chen when he pointed out, what's the point of having these committees that review Canada's compliance if Canada can just turn around and say, sorry, we don't agree. To Shalini's point about we've done this before. We know we can do this before. We know we can do this again. We've done this before during COVID-19. Everybody had access to healthcare in Ontario. When we ran the numbers, it turned out that it cost Ontario about $7 million and some change in the year 2020, 2021 to provide healthcare for uninsured folks. Nobody can make the argument that it's too expensive. We know that it's not only is it not expensive, but it's actually the most economical way forward, because if you have access to healthcare when you need it, you're going to save costs to the public system down the line. We know that we can do it. There's no reason why why we should not be doing it right now. I just want to end with moving words from Kedi Nivyabandi, who is the Secretary General of Amnesty International Canada, who said about Nell, "Ms. Toussaint bore injustice in her bones throughout her life, but refused to let it deter or silence her." And I think we can all agree that we have so much to learn and celebrate from Nell's indefatigable fight, and I hope that we all do her justice in carrying her legacy forward. Thank you very much.
All righty. Thank you very much to all of our panelists. We've now got about half an hour for some Q&A. So as I mentioned at the outset, I'd invite you to put any questions that you have or comments in the chat, the Q&A, or you can raise your hand either in person or online, and we can just gonna open that Q&A. Okay, so maybe I will start things off while people are getting their minds turned towards some questions, and we've got Shalini up on the screen there. So I'm wondering, maybe Shalini, given your experience, extensive experience in terms of advocating and appearing before various UN human rights bodies, if you can speak a little bit about the upcoming Universal Periodic Review, if you can provide some insights into what's going on at the moment.
Absolutely. So our most recent review is completed, and Canada appeared before the UN's Universal Periodic Review in the fall. Upcoming now is that they're going to respond to the recommendations that were made. And I think what's most interesting about it, because that UN experience can be frustrating, and to the point Adi just made, sometimes you think, what is the point if Canada is not going to implement anything? And so I think a couple of things that I'm thinking about are that Canada is right now actually, I think, in a process to bid for a UN Security Council seat. And so as domestic organizations, I think we have opportunities as individuals and organizations to push Canada to actually put some teeth into its response to the recommendations of the Universal Periodic Review and so many other committee recommendations. And if you actually read many of those recommendations, they're the same ones that have come from previous cycles, and they echo the same issues. And I think what we can do is, if people are interested in keeping an eye out of Canada's response, I think what would be really great is, I suspect that their response is probably not going to be adequate for what I'm looking for, and likely what a lot of people are looking for, and that we domestically have to figure out a way to get Canada to be more accountable to us for their response to these issues, and including the treatment of the large number of migrant workers. And many recommendations have been made, including the healthcare one around this. And so we might have a good opportune time when Canada releases its response to push back and say, this isn't good enough, we need this. I'm presuming that it won't be good enough. And I think probably that's a fair presumption. And so those are tools and levers that we can use. You can see the challenge though, right? Getting decisions that Canada has decided they're just not going to implement. So I think we have to think about, you know, the UN and the Universal Periodic Review as one lever, but we also have to do this test case work. We have to do public advocacy. And the reality is, in my own work, the changes have come when we've been able to demonstrate and develop a political will, right, to make the change. And so we do a lot of this work around test cases, the UN work, but really the reality is that if we can get the political will and the voice of people to get to decision makers, I think the change can come from that as well.
Thanks very much. Okay, then question in the chat. What is the proportion of the provincial population which experiences precarious healthcare coverage on an annual or long-term basis? Professor Chen, do you want to take that one?
So obviously, I think the answer to that question will vary from province to province. And also, we don't have very good figures when it comes to actual number of people who are not insured. The only figure that came to mind, this is quite old now. I would say at least a decade old, but it's widely accepted that here in Ontario anyway, that generally speaking, there are about 500,000 people who are without insurance. And many of those will be people without legal status here in Canada. So that is the rough estimate, at least here in Ontario. But again, it might vary from province to province.
One of the things that Color of Poverty has been working on is that data collection piece from Immigration, Refugees, Citizenship Canada and Canada Border Services around having a true reflection of understanding the data on who is out of status in Canada. And it's not always going to be perfect data, but there's a massive kind of failure to collect disaggregated data at the immigration level that can answer those questions. And in my view, those are intentional choices too.
Thank you. Question about community health centers. So in Ontario, OHIP, there's a belief that OHIP is not required at community health centers, CHCs. What are the limitations of that access, and does it meet the healthcare needs of this population? So maybe, Shalini, we can start with you, and then if Professor Chen or Adi have anything to add.
Sure. And community health centers have been a tremendous resource for our clients. A couple of problems. One is that they're in particular pockets. So I work across the province. So depending on where you are in the province, you may not even be remotely close to being able to get to a community health center. So that's one of the biggest things. There's that actual physical access issue. And then the second piece is, I know that our experience has been that they're just so overwhelmed with work that there are huge capacity issues in terms of taking on clients and taking on people. And so I think those two things in particular are a real barrier. I do believe that there are some limitations in terms of the types of things that they can provide support with. There are certain conditions that require more than what can be offered at the community health center. And certainly when clients have emergencies, that may not be an option. So that timeliness of care is an issue as well.
So yeah, I would just add, so everything that Shalini said was absolutely true. I would just add a couple of points. One is with respect to the physical access of community health centers. It's also notable that it's not true for all community health centers, but some do have eligibility requirements that require whoever uses the service to be living within a certain what they call catchment area. So, even if you somehow are able to get yourself to those particular CHCs, it may be that you're not qualified to be served because you're actually simply not living within what they call the catchment area. And another point, this has to do with again what Shalini has said is the fact that there is overwhelming demand for CHCs and also the lack of resources. And that creates situations such as long wait time, right? And also the amount of funding that each CHC has to serve people who are not insured under Ontario Health Insurance Plan is predetermined year by year at the beginning. And so we've often hear stories about how each CHCs, they quickly run out of that pot of money by middle of the year, right? And so, you know, what do you do with people without health insurance who come to your door and needing services perhaps towards the end of the year, right? Somehow CHCs have to find alternative resources to cover the cost of treating these individuals.
So yeah, maybe I'll just add very quickly, just to say that I think when we talk about community health centers too, it's obviously very, in some ways, very uniquely Ontario thing. Not every province has community health centers. When they do have community health centers, they may be called something different. But particularly in rural provinces, a province in which I do a fair amount of work, and some of my colleagues from the Madhuvarma Migrant Justice Center in New Brunswick are online right now. In rural provinces like New Brunswick, the challenges are compounded by lack of access to the public transit, the fact that there are so few of these centers to begin with, and they only exist in urban areas. And many of the migrant workers that work in the industries in provinces like that are often working in rural communities. The fishery plants, the agricultural farms, these are all far away, and they have to rely on their employer to get anywhere, and live under constant surveillance. So, if they're injured, if they need healthcare, there's actually a chilling effect to even go and seek it, because you don't want the employer to think that you can't work, because if the employer thinks you can't work, you run the risk of either not being able to come back the following season. You run the risk of being retaliated against in one way or another. You might have to pay out of pocket to even get healthcare, even if you are insured through a private health insurance company. The general practice is you pay out of pocket and then you get reimbursed later, but that assumes you have money to pay out of pocket to begin with. So there's all kinds of limitations, even when some facilities do exist, for sure. That was a great question.
Thank you. Wondering if one or more of the speakers could comment on the divergence between how Canada interprets the right to life and how international law approaches it. Is it just about who bears the cost? And is that something that we see with other key international human rights? This is a multi-part question, so I'm going to continue. Are there cost estimates on the savings or value if Canada implemented the decision as opposed to spending money on emergencies? And by value, that also includes the contribution to the social and economic life of the country if precariousness was not an issue. So, who would like to start tackling that very excellent set of questions? Bruce, would you like to do that? Yes. Okay, wonderful. You know what? I'm going to bring you the mic. Or would you like to come down? Yeah, that would be great. So we have our wonderful expert, Bruce Porter, in the audience. He's going to join us. And
thanks. Thanks for that great question, Constance. You know, the Nell Toussaint case of the UN Human Rights Committee really converged with a really huge development in international law, where the right to life has gradually become understood in a much broader sense as requiring states to address issues like climate change and access to healthcare and homelessness. And this has been emerging in a lot of other courts. It's in the international system. It's in the regional systems, that you can't protect the right to life if you don't deal with issues like homelessness and hunger and climate change and so on. So Canada is increasingly out of step with the developments in international law. And the Canadian government is even increasingly out of step with its own courts, because courts have really recently begun to reject Canada's argument that there are no positive obligations to protect the right to life, and it's only a negative right to protect people from being killed. Nobody buys that anymore. And so in climate change cases and so on, courts have not accepted Canada's argument. And in the Toussaint case, the court rejected Canada's argument that the right to life doesn't impose obligations on governments or may not impose obligations on government to ensure access to healthcare. And Shalini mentioned the idea that the right to life is now interpreted as including a right to life with dignity. It's incorporating understandings of the right to life from Indigenous understandings of life. So it's a hugely important area of international law, and something that I think we're in a good position to push Canada on and say, why would you want to be out of step with these fundamental understandings now that are accepted worldwide, that the right to life has to ensure that people have access to basic requirements for a life of dignity, like access to housing and healthcare and food. So I think that the Universal Periodic Review coming up is a really ideal opportunity for us to push Canada on a number of recommendations, including on access to healthcare, to accept that we have to recognize that human rights do protect access to things like housing and healthcare, and we've got to get our governments to get on side of that.
Any of our other panelists want to comment? That was very, very helpful, Bruce.
I think in terms of the costing piece, I think there's been a lot of data put out across the country around how preventative healthcare is a savings for the healthcare system, right? And so I think we're already there. And I think it was Adi who had already mentioned that we have some costing information now on the coverage during COVID, which really tells us that providing services to these populations is not costly, right? And not even taking into consideration what the preventative benefit was. So I don't have the specific numbers, but we know in Ontario, in an analogous sense, for legal aid, the system that I work in, every dollar put into the legal aid system in Ontario saves the justice system $6, right? And so we know that this approach, which takes us to the front end of the preventative end and the ongoing end, does have a cost saving for the entire system in the end. And so that piece is certainly one of the arguments. I mean, fundamentally, from my view, this is a human right. This is a right to life question, and this is a right to life with dignity question for me. But also, we do make those arguments, right, on the cost benefit analysis. And the reality is, I think there's a lot of data out there around how preventative healthcare saves the healthcare system in the end. And so it's something absolutely that we should be considering. But the reality is, even if it didn't have those cost savings, I still think that we have an obligation to provide that coverage.
Thank you. Either of you want to add anything?
So just on the cost point, I agree everything that was said, and I think 2 points I just want to make. One is, I think in the immigration context, particularly, we often think of immigrants or migrants, generally speaking, as a potential burden on whatever system that we have, right? And so that speaks to the idea of cost, and not, as Constance, you mentioned, right, not really taking into account, for example, if we truly want to do a cost-benefit analysis, talking also about the kind of contributions, whether economically, socially, and in whatever other forms that migrants, generally speaking, do make to our society, right? So if you do want to make that kind of calculation, let's make that calculation more a wholesome one, rather than simply thinking of migrants in a very stereotypical way as a burden. And second is more specific in the Toussaint case. I just want to also highlight an often forgotten a piece of fact that, sometimes people talk about, and this is actually put forward by Canada as a reason why Canada, generally speaking, only provides public funded healthcare coverage to residents, but not other people, right? And one of the argument being that, well, because they pay taxes. I mean, healthcare apparently is described as a contributory social insurance. So if you contribute, you get something back. And the assumption, obviously, there is that migrants, particularly irregular migrants like Nell, didn't contribute to the pool. But as we know, actually in this particular case, it's not true, right? The facts that are accepted by federal court in this case actually indicates that, from time to time, Nell's employers actually deducted various tax deductions on her payroll, right? Like she did make contributions even though she was working without a work permit. And so even on that very, kind of reciprocity sense, right, Nell did make a contribution, if you want to argue, to the health system. And so, I just want to make sure that nuance is not forgotten.
I had one
Yeah,
thing.
of course.
Oh, the only thing I want to add to what's been said already is that it's not, and it's not just that it's that it's cost efficient because it's publicly funded, but it has to be publicly delivered for it to be cost effective. What Doug Ford has said, you're gonna use your health card, not your credit card, to pay for healthcare. That's all well and good, but your health card is still paying for the CEO's new limousine when you use your health card. So it's not really that cost efficient if we're using taxpayer dollars to subsidize private profit. So we have to keep in mind as well that when we do talk about the cost-based arguments around this, that it's the profit motive that corrupts the system at the very basic level.
All right, we've got time for two quick questions in the room. We'll start with Professor Jackman.
Thanks. Such a great panel. And I guess I just want to underscore that aspect of Constance's question in your responses is I think the government knows it's false economy. And so there are other reasons why it persists in refusing. And I think part of it is breathing down their neck in the House of Commons right now. And I think this point that we need to be able to quantify properly the full costs and benefits of these policy choices is something that has been hard for us to do as Stats Canada and left-wing economic think tanks have also been, defunded or are struggling, so that we're trying to make these human rights claims without a strong ability to marshal the evidence, as you said. I mean, anyone who's been to Superstore, Tim Hortons in any part of Canada, over the holidays has to be aware of to what extent we are living on the backs of temporary workers here in Canada, and they are paying taxes and they're paying premiums and they're not being treated fairly. And I think if we can't put dollar figures to that cost benefit, we are going to lose the PR political rhetoric war that's going on right now, I think, with populism and the right. So I'm not clear how we make those linkages, but I think we really need to be focusing on that.
Thank you. Okay, final question here in the back.
Hello, thank you guys for the presentation. I'm just wondering why, in your opinion, the government of Canada feels comfortable in these court cases, relying on the stereotypes about migrants to support this case, and if the judges are still receptive to these arguments, and if Justice Perel's opinion is just an outlier. Thank you.
Who would like to start with that? Okay, Professor Chen.
So I'll make it quick. So I think these kind of arguments keep coming up, both in court and outside of court, simply because it actually has quite a bit of resonance, right? I think, as I said, in my research in this area, a lot of people actually conflates this idea of migrants being, for example, health tourists, right? And in fact, there's this whole body of literature on what we often call welfare magnet hypothesis, right? The idea is that people come to a country or a particular jurisdiction because they're attracted by the welfare system there, whether it's healthcare or social assistance. And I think that's why that kind of stereotype keep coming up, and even, you know, to a point being used by Canada, right? And it was used, for example, in the litigation that was challenging the interim federal healthcare cuts back in 2012, right? The whole idea that these are not genuine refugees. The only reason that they're here is to get what, quote unquote, the government said, gold-plated healthcare, right? And so that's why I think you see that stereotype coming up. And thankfully, right, you have at least two examples, both in Justice Perel's decision and also in the decision for relating to the interim federal health cuts that I just mentioned, where both judges kind of dismissed those arguments. And in fact, in the interim federal health litigation, the judge actually gave Canada an opportunity, right, to kind of come up with evidence that suggests that these are not actually refugees, but what Canada called fraudulent migrants. But Canada couldn't come up with any concrete evidence to dispute or to kind of support its argument that these are fraud. So I think that in of it speaks to the lack of evidential support for that stereotype. And again, the fact that it's still coming up is unfortunate.
Shalini, last word to you.
Oh boy, it's a very like rage-filled last word. So the reality that I see in doing immigration in the past 20 years is that as we've had more people coming in from racialized communities, the conversation in immigration around people simply trying to defraud our immigration system has grown. So there's an intersecting thread there. And it's across the board that Canada makes arguments within the immigration context that people are somehow trying to come here and defraud us. A great example of that was when they introduced conditional permanent residence in spousal sponsorship cases, and then went ahead and investigated thousands and thousands of people if they left their spouse after getting immigration to Canada. The data told us that 98% of those cases where people had left was because they were victims of domestic violence. And so the program was shut down. And so I think in the same, under the same vein, Canada continues to persist with this idea that migrants, immigrants, visitors, international students, temporary workers are somehow coming here to use us. What is confusing to me is that at the same time, we continue to see our government tell us we very much need all of these people to support our economy, to support our communities, to support our populations. But at the same time, these are the same people who are coming to defraud our country of its precious, precious resources. And that does not bear out. And just as Professor Chen said, when presented with an opportunity to provide evidence that this fraud is so rampant, Canada cannot do it. And the reality is because it is not. People who work with these clients, these communities, know that it is not, right? And so that part is deeply frustrating. But to end on an optimistic note, I just want to reiterate what Bruce said, which is that in doing test case work, we are seeing good things happen in the courts. We are seeing, I am seeing in my federal court work, an approach and a lens to that decision-making from judges that is far extended, that takes into consideration discrimination, systemic racism, that takes into consideration an extension of human rights as a positive obligation, not just a negative sort of protecting one thing. And so I think our courts in our test case work are making those considerations and are moving, maybe a little bit too slowly for me, towards a new style of thinking. I think we need to think about why Canada isn't in and of itself moving towards that lens.
Thank you. I'd like to thank everybody for their participation today. It's been an absolutely wonderful discussion, and wish everybody online and in the room a wonderful rest of your day. Thank you very much.